This episode of Legaleagle was made possible by Skillshare. Learn to think like a lawyer for free for 2 months by clicking the link in the description. Christian rapper Flame sued Katy Perry claiming that this song copied this song. A jury agreed and awarded him $2.8 million. But when a jury found that the writers of Katy Perry's 2013 hit Dark Horse featuring Juicy J had copied part of a 2008 song called Joyful Noise by Christian rapper Flame, it set off a major firework in the music industry. The jury ordered Perry and the other writers to pay almost $2.8 million to Flame for copying a small part of his song. However, after Perry's lawyers filed a motion to overturn the verdict, the trial court decided it was time to hear it roar. See what I did there? In March, the court threw out the jury's verdict, dismissing the case. And believe it or not, Katy Perry was saved by none other than Led Zeppelin. I am not kidding, that is actually what happened. To understand how this case wound up being so controversial, we have to take a dive into federal copyright law and music theory. So strap in. Hey, Legal Eagles, it's time to think like a lawyer because I'm just a California girl. No more Katy Perry references, I'm sorry. The dispute over Dark Horse is not about the songs themselves, but about a short 8-note melody that Flame believes the Dark Horse writers copied from his song Joyful Noise. And it's true, they both have a similar musical component called an ostinato, and that's actually sort of unusual for a copyright case. See, usually in lawsuits like this, you're comparing the entire song. For example, George Harrison was successfully sued by the Chiffons over his song My Sweet Lord, which was suspiciously similar to the Chiffons' He's So Fine.
My sweet Lord, my Lord, he's so fine, wish he were mine.
Here, the songs are pretty different, but the songs at issue do have a similar component. They're ostinatos. An ostinato is a short melody or pattern like an arpeggio that is constantly repeated throughout the song, usually in the same part at the same pitch. However, proving copyright infringement in music is complex because there are only a limited number of notes and arrangements available to composers and musicians. If you listen to the radio for 30 minutes today, for example, you will hear common themes repeated in many songs. And it's for this reason that the individual elements of a song simply are not protected by copyright. And that's why music industry professionals were alarmed by the Perry verdict for $2.8 million. Many songs use the same musical building blocks. If one musician can copyright the underlying structure, it would radically change the musical landscape and allow for musical monopolies. But I'm not an expert in music theory. If only I had some expert I could turn to explain the musical concepts at issue. Wait a minute, I've got an idea.
Well, it appears that I have been summoned. So Joyful Noise and Dark Horse both employ similar ostinatos. An ostinato is a simple repeated melodic fragment on top of which a songwriter or composer might write more prominent melodies. So it's kind of like the backbone of a composition. Both songs' ostinatos are very similar, as the defense pointed out. They both are in minor keys. They both have the same rhythm of 8 evenly spaced quarter notes. They both start on the 3rd note, or scale degree of the minor scale, repeat that note 4 times, then descend down to the 2nd note of the minor scale and repeat that note twice. After this, Dark Horse's ostinato descends to the 1st scale degree and then below to the 5th scale degree. And Joyful Noise's ostinato actually changes every other time. The first time it resolves to the 1st scale degree, and the second time you hear it resolves down to the 6th scale degree. So technically they're different, but they are very similar in the fact that they both are ostinatos, they're in minor keys, they have the same rhythm, and they both start the same way with the same scale degrees. Now the problem that I have with this is that these elements aren't remotely unique to Joyful Noise or Dark Horse. You can find any combination of these elements in our shared musical tradition quite easily. For example, 8 quarter note ostinatos like Pachelbel's Canon in D, or for example, minor key ostinatos that start on the 3rd degree and descend down to the 1st degree like Carol of the Bells, or of course, the bass line to Fancy by Iggy Azalea. Or you could get specific, like 8-note melodies in minor keys that start on the 3rd scale degree, repeat 4 times, and then descend down to the 2nd scale degree, and then repeat again. You can find that in Bach's Violin Sonata in F minor, the Adagio movement. Now, taken individually, these points of similarity are banal. They represent really fundamental building blocks of music. Even that specific sequence of notes of the 3rd degree going to the 2nd degree.
Thanks, Adam, really appreciate it. And I promise only to summon you if it's a musical emergency. Definitely check out Adam's channel if you have any interest in music theory or bass guitar in general. It's amazing. And as Adam points out, the 8-note ostinato in Dark Horse sounds a lot like the ostinato in Joyful Noise, but that's not the end of the analysis. There are lots of different ostinatos that sound similar to that. Just because something sounds similar doesn't necessarily mean that there was copyright infringement. The ostinatos at issue sound like a whole bunch of other songs. Are all of these songs infringing on each other? To understand the answer to that question, we have to take a deeper dive into the songs themselves and into copyright law. To prove a claim of copyright infringement, the copyright owner has to prove 2 elements. First, the person has to own a valid copyright, and 2, they have to show that the protectable portions of the copyrighted work have been infringed, and infringement is usually defined as unlawful copying. Now, while that sounds like a clear test, it's really just the tip of the iceberg. To prove unlawful copying, you have to show that a person actually copied the work at issue, which usually requires proving access. And it also requires proving substantial similarity, which is that the things that were copied give rise to the standard that we say that it was enough copying to constitute copyright infringement. Now, access and actual copying are really important because technically, independent creation is a defense to copyright infringement. If you happen to come up with the exact same form of art, technically, if you say were on an uninhabited island in the South Pacific when you created this thing, well, then there was no way for you to have copied someone else. So not only does something have to be substantially similar in terms of what is created, but you also have to prove that someone had access to the thing that was copied and that they actually did do the copying itself. And in most copyright cases, direct evidence isn't available. So that's why creators rarely have proof that the defendant actually listened to a song or directly pilfered parts of it for their own use. Instead, plaintiffs rely often on circumstantial evidence to make their case. Now, that's just to prove that copying of some form existed. But what about the test for substantial similarity to prove that the things that were copied in a way that gives rise to copyright infringement? Well, in determining whether 2 works are substantially similar, the courts use a 2-part analysis, an objective extrinsic test and a subjective intrinsic test. Now, the subjective intrinsic test is almost always a question for the jury. It's something a court can't decide itself. It asks, would a normal person with no background in musicology or in whatever kind of art is at issue here, would they feel that the 2 works are similar enough that copying is actionable? But the extrinsic test considers whether 2 works share a similarity of ideas and expression as measured by external objective criteria. The extrinsic test requires analytical dissection of a work and expert testimony, and that dissection means that the court will break down the works into their constituent parts and compare their elements. This is an analysis that the court, the judge in this particular case, can do. It's objective. It's based on the face of the works themselves. And when a court conducts this analysis, it's looking only at the protected elements of a copyrighted work. It's always essential to distinguish between the protected and unprotected material. For example, if something is in the public domain, you can use it and you can make a new work, but you only get protection over the new protected elements, not the unprotected things that are in the public domain. And this is where Flame ran into trouble with the court. He was unable to show that one brief section of Joyful Noise was sufficiently original in its protectable, copyrightable parts. And not every part of Flame's song was copyrightable. For a creative work to be entitled to copyright protection, it must be an original work of authorship. And when the Supreme Court defined originality, originality, it set a pretty low bar. A work is original if it is independently created and possessing at least some minimal degree of creativity. And as I mentioned before, this is a really interesting case because usually you're dealing with the whole song or the whole book or the whole movie. Here, we're not talking about both songs in their entirety, but merely constituent parts. And some musical elements are not protectable at all, such as a chord progression, or a recurring vocal phrase, or a syncopated rhythm, to name just a few common elements of songs. As one court remarked, these are building blocks which belong to the public domain and cannot be appropriated by any particular author. Because in Western music, there's only so much stuff you can do within the key of a song. Musical emergency.
You see, in Western music, we have this thing called tonality, where all the notes of the scale have a specific function to play. They want to do certain things. So if you're writing a song using tonality, which chances are, if you're writing a pop song, it's gonna be tonal, there are a very limited number of ways each note can plausibly resolve to the next in a pleasing manner. And if you're writing a pop song, you want it to be pleasing in theory. So, well, yeah, the two ostinatos are similar. Musically, that doesn't mean a whole lot.
Yeah, and what's really interesting here is that we're dealing with a small subcomponent of a song, the ostinato. By way of analogy, imagine you have a copyright infringement case with two novels. The whole work itself would be the novel. That novel is broken up into subcomponents, either sentences or words. And those words themselves are broken up into letters. I'm not aware of any particular copyright case that allows you to copyright an individual word. It's too small. But you can string a whole bunch of letters together to form words, and then string a whole bunch of words together to form an entire novel. And at some point, it has the creativity necessary to be copyrightable. And a song is the same way. If you start with the whole song that is made up of individual components, often musical phrases, or maybe it's a drum line versus the melody and the vocal melody and the words, and those things are made up often of individual notes, just like letters make up an individual word. And I suppose it could be theoretically possible to have a very small number of notes to form a copyrightable work. But you would imagine it would be very, very difficult to have an 8-note musical phrase become a copyrightable thing itself. And in fact, the Ninth Circuit has found that a 4-note melody is not copyrightable. Here we're dealing with 8 notes. And obviously there's a spectrum. At some point you go into the hundreds or thousands of notes and that becomes an entire song itself. And here, although the jury heard extensive testimony about the similarities between Joyful Noise and Dark Horse, the plaintiffs simply couldn't prove that the 8-note ostinato was original enough to receive copyright protection. Expressions that are standard, stock, or common to a particular subject matter or medium are not protectable under copyright law, is what the judge found. Now, the plaintiff's expert musicologist identified 5 distinct elements that he thought were protectable as they were used by Joyful Noise. In the plaintiff's brief, they identified even more elements, a total of 9, that they thought deserved copyright protection. And in response, Katy Perry and the other defendants argued that it didn't matter whether there were 3 or 5 or 9 elements, since none of them were protectable on their own. And in a win for Adam Neely, the court also referred to other songs that featured very, very similar ostinatos, like Merrily We Roll Along and Jolly Old St. Nicholas, to explain that the particular ostinato was not copyrightable. But the court didn't stop there, because there are circumstances where you can string together a series of unprotectable elements to form a larger protectable thing. I mean, that is what a novel is. Every individual word is not copyrightable, but if you string enough of them together, then that does eventually become copyrightable. So in theory, Flame could have proven infringement of the ostinato if he was able to show that the combination of unprotectable elements are original enough in the way that they are arranged. And you can combine non-copyrightable things together to get protection. But when you do that, you generally get what's called thin copyright protection. If the underlying things themselves are not copyrightable, then the only thing that you get copyright over is the actual arrangement itself. And when you are dealing with thin copyright protection and you claim that someone has infringed the copyright on your selection, then generally those two things have to be virtually identical or there is no copyright infringement. And as the court found, it is undisputed in this case, even viewing the evidence in the light most favorable to the plaintiffs, that the signature elements of the 8-note ostinato and Joyful Noise is not a particularly unique or rare combination, even in its deployment as an ostinato. Prior compositions, including prior works composed by the the parties, as well as what all agree is a separate non-infringing ostinato in Dark Horse, all contain similar elements. Since the sole musical phrase that Flame claimed was infringement was not a protectable expression, the extrinsic test was not satisfied, and therefore Flame's claim failed as a matter of law. Whew, God, that was hard to say. Now, it's theoretically possible to copyright a musical phrase, but it would need to be really, really special. It is, as it should be, really hard to copyright subcomponents of songs because lots of people use the exact same thing over and over again. We have a musical library that is inherent to Western music. Imagine if someone tried to copyright this drum rhythm. Or if someone tried to copyright this lick. Sorry, man. False alarm. Sorry about that. Now, Flame's expert musicologist pointed to 9 elements that he claimed, when taken together, made an otherwise non-copyrightable set of notes copyrightable. He pointed to a melody built in the minor mode, a phrase length of 8 notes, a pitch sequence beginning with 3-3-3-3-2-2, a similar resolution to both phrases, a rhythm of 8 notes, a square and even rhythm, the structural use of the phrase as an ostinato, the timbre of the instrumentation, and the notably empty and sparse texture of the compositions. The thing is, none of these things by themselves are copyrightable, and even when you use all of them together, it doesn't turn an otherwise non-copyrightable thing into a copyrightable phrase. If the sheet music isn't copyrightable, you can't get protection by playing that same thing on a synthesizer. It's theoretically possible to get a copyright over the selection of unprotected elements, but you have to show a ton of creativity, and more than what Flame has alleged here. It would be much easier to do if he was claiming that the entire song violated the copyright, rather than just this really small part that is otherwise similar. Now, the court went on to note that even if the ostinato was creative enough to be considered protectable under copyright, it wasn't substantially similar to the Dark Horse ostinato. In other words, there was no actionable copying or copyright infringement. A selection of a song is only infringed if the two works substantially share the same combination of protectable elements. And remember, the actual notes themselves in this case were not protectable. And this is where Led Zeppelin saved Katy Perry. Yes, seriously.
Does anybody remember laughter?
See, in this case, the protectable elements would be so narrow that a combination of protectable elements between the two songs would need to be virtually identical. And the court held that Flame was unable to satisfy this test for substantial similarity. In making this decision, the judge referred to another huge copyright case that the Ninth Circuit Court of Appeals decided just a couple of weeks ago. There, the Ninth Circuit upheld a 2016 decision that Led Zeppelin's Stairway to Heaven did not infringe on the band Spirit's 1968 instrumental track, Taurus. Now, these two songs are much, much closer than Dark Horse and Joyful Noise. Here's Led Zeppelin's unbelievably famous intro to Stairway to Heaven. And here's Taurus's song Spirit. Now, to my ear, those songs, and here we're talking about the whole songs in general, sound much, much more similar than Dark Horse does to Joyful Noise. And the Ninth Circuit agreed. It held, we have never extended copyright protection to just a few notes. Instead, we have held that a 4-note sequence common in the music field is not the copyrightable expression in a song. And in Led Zeppelin, in order to prove copyright infringement, the two works at issue would need to be virtually identical. The court found that Stairway to Heaven and Spirit were not virtually identical, just as the court did in Katy Perry. Now, the Led Zeppelin case had mainly to do with whether a defendant's access to a song can be used to prove copyright infringement or plagiarism. The Ninth Circuit actually reversed a precedent called the inverse ratio rule that had lasted for 45 years. And this is an issue I have actually litigated, and that particular rule deserved to die. See, the inverse ratio rule meant that the more access that was shown between the alleged copyright infringer and the original copyrighted work, the less substantial similarity was required to establish infringement. That enabled enabled plaintiffs to allege copying if they could show that the defendant had likely heard the song. And between Led Zeppelin and Taurus, well, they toured together in the 60s. So there was almost no doubt that Jimmy Page had heard Taurus's song. But the thing is, that probably shouldn't matter. Just because someone might have heard or had access to a song or other creative work doesn't mean that we should change the standard required to show that two things are similar. The more access doesn't mean the less similarity that you have to prove. That unfairly burdened songs that simply got a lot of radio airtime. The music industry has actually been critical of this rule for decades, especially since it was not used by courts outside of the Ninth Circuit. One reason the music industry hated this rule was because access was so much easier to prove in the age of digital streaming. Everyone pretty much has access to any other songs. And in fact, Adam Neely did another video talking about a group of people who tried to copyright every conceivable melody that could possibly exist in the world. And they sort of recognize, though, that not everyone has access to this hard drive of songs that they created, so it might not actually solve the issue that they're dealing with. Definitely check out that video. But after the Led Zeppelin decision, to the extent that the inverse ratio rule ever existed, which is sort of an open question, at least in the Ninth Circuit, that rule has been completely abolished. And as in the Led Zeppelin case with Katy Perry, when you filter out the unprotected elements of the songs at issue, there just isn't much left, and there certainly isn't enough to justify copyright infringement. Now, those astute legal eagles out there are probably wondering, how come this case turned out different than the Marvin Gaye Blurred Lines case? Well, that is a really interesting quirk of procedural law, because Katy Perry also lost a jury verdict, but then was able to overturn it. What happened with Robin Thicke and Blurred Lines? Well, now, it's of course possible that Katy Perry may in fact lose her case on appeal, but I think that's probably really unlikely. See, copyright issues are complicated, and they're often decided as a matter of law by the court. Factual disputes, such as who is lying and who's telling the truth, are decided by a jury. But issues of law can be decided by a judge, and generally, if you can, you want your case to be decided by a judge quickly before it gets to a jury, because a jury can do anything, who knows? Now, in certain cases, you can ask the judge to decide in your favor as a matter of law before it gets to trial. Here, Katy Perry's lawyers made a motion for judgment as a matter of law before it got to the jury. The judge denied the motion, and the case went to trial, where the jury found in favor of Flame and awarded him $2.8 million. But under the Federal Rules of Civil Procedure, Rule 50, if you made a motion before the trial, then you can make a renewed motion afterwards. But you have to make that initial motion. And that's what happened here. Katy Perry made the motion, it was denied. The Led Zeppelin case came out in the interim. They refiled after the jury verdict, and then the judge, looking at the Led Zeppelin case, said, okay, this is on point, and decided in Katy Perry's favor, and basically overturned the decision of the jury. The court basically said no reasonable jury could have found in favor of the plaintiff, which is funny because all 12 jurors did find in favor for the plaintiff, but that's neither here nor there. Now, if a party fails to make a Rule 50 motion at the close of evidence, that party waives its right to challenge the sufficiency of the evidence of the verdict later on. This can be a very serious mistake. And to prove that, all you have to do is ask Robin Thicke and Pharrell's lawyers, because they did not make a Rule 50 motion for judgment as a matter of law. And so after the jury found against them for millions of dollars, they weren't able to make a renewed motion afterwards. And it's entirely possible that had they done that, the court would have sided with them, because a lot of people, a lot of musicologists believe that the Blurred Lines lawsuit was incorrectly decided. So the bottom line is that copyright law is complicated and it's hard. Both the Led Zeppelin and Katy Perry decisions are examples of courts pushing back against the Blurred Lines verdict. And I think it's going to be a lot harder to prove copyright infringement in the Ninth Circuit, for better or worse. People borrow from predecessors' works and create new ones, especially in the music world, and we all share this common vocabulary. But at the end of the day, not all copying is copyright infringement, just like not everything that glitters is gold.
Does anybody remember laughter?
Now, whether you're on the side of Katy Perry or Flame, you can see how both of them use similar building blocks to make their world-famous songs, because making music is actually surprisingly easy. If for any reason you're spending some extra time at home and want to learn how to make your own music, I highly recommend Mike Boyd's Skillshare class, Guitar Fundamentals Learn Quick with Mike Boyd. In this class, Mike Boyd walks you through the basics of learning to play the guitar, starting simply with the anatomy of the guitar and leading all the way up to playing your first 2 songs. Honestly, you probably don't even need much of a lesson to be able to play the ostinato from Dark Horse. But even if you've never picked up a guitar in your life, Learn Quick's Mike Boyd will show you what you need to know. It's a great way to learn a new skill. Or if you want to learn another skill, you can check out Mike's other Skillshare class, How to Learn Strategies for Starting, Practicing, and Mastering the Skills You've Always Wanted, which helps anyone learn something new, reduce their likelihood of quitting a new challenge, or get good at something faster. And now is a great time for people to stave off boredom by learning new skills. Skillshare is an online learning community that has tens of thousands of classes on everything, like music, design, technology, and business. It's great for anyone that wants to learn a new skill, like learning a guitar or other musical instruments. A yearly membership is less than $10 per month, but the first 1,000 Legal Eagles will get 2 free months of Skillshare when you click on the link below. Plus, it really helps out this channel, so just click on the link in the description. The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things, all free for 2 months. So improve yourself now while you finally have the time. Do you agree with my analysis? Leave your objections in the comments and check out this playlist over here where I talk about all kinds of copyright related things. So click on this playlist and I'll see you in court.